Well, folks, before we get going, I want to first apologize to all of you. We're running a little bit late. We had a judge call in sick, and so I was across the street in the jail handling things that had to be taken care of over there. We had landlord-tenant cases, all sorts of things. So I was taking care of those, and then I'm late getting over here. So I do apologize to you all for having you sit without letting you know that I was running late. With that, let me get my head on straight. We have the State of Oregon versus Douglas James Dean Cobb, case 22 CR 60445. Are the parties ready for trial?
Yes, Your Honor.
Yes, sir.
All right. And so, potential members of the jury, if I can get the 17 of you to please stand, raise your right hand. My assistant's going to swear you in.
Do each of you solemnly swear or affirm the evidence you shall give as to your qualifications to sit as a juror without outstanding should be the truth, the whole truth, and nothing but the truth? Okay.
Yes.
Thank you. You all may have a seat. So folks, before we begin, please make sure that all cell phones, laptops, and other electronic devices are turned off. They must remain off while court is in session. Oftentimes I have jurors or participants think that they turn their phone off, and then it rings during the middle of the proceeding, and so please take a moment to make sure that your phone is on airplane mode or all the way off. It must remain off while we are in session. So ladies and gentlemen, today we are selecting a trial jury for the criminal case of the State of Oregon versus Douglas James Dean Cobb. The state is represented by Connor Amundson, and the defendant is represented by Wyeth Holman and Emily Denniston. The defendant is charged with the offense of unlawful dissemination of an intimate image, alleged as follows. The defendant, on or about November 19, 2022, in Polk County, Oregon, did unlawfully, with the intent to harass, humiliate, or injure SL, knowingly cause to be disclosed an identifiable image of SL, whose intimate parts were visible, when the defendant knew or reasonably should have known that SL did not consent to the disclosure. SL was harassed, humiliated, or injured by the disclosure, and a reasonable person would be harassed, humiliated, or injured by the disclosure. To this offense, the defendant has entered a plea of not guilty. A plea of not guilty denies that the defendant is guilty of the offense. Under our system of justice, the defendant is innocent of any crime or wrongdoing unless and until the state proves the defendant's guilt beyond a reasonable doubt. Therefore, the burden is on the state to prove the defendant's guilt beyond a reasonable doubt. Some of you may have served as jurors in civil cases where lesser standards of proof apply. For example, proof by a preponderance of the evidence or proof by clear and convincing evidence. In criminal cases, however, the state's proof must be more convincing. It must be beyond a reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt means an honest uncertainty as to the guilt of the defendant. As a juror, you must return a verdict of not guilty if, after careful and impartial consideration of all of the evidence in the case, you are not convinced beyond a reasonable doubt that the defendant is guilty. Each juror must be able to judge this case fairly and objectively. Therefore, if any juror knows of or has any association with any of the parties, the lawyers, or the witnesses, or if any juror has any knowledge of or has formed any opinion about this case, this should be brought to the court's attention. So first, do any of you know the defendant or any of the lawyers? If so, please raise your hand. And for the record, we have no hands being raised. The following people may be called as witnesses in this case. You may hear from Stephanie Loggins. If any of you know any of these persons, or if any of you know Miss Loggins, please raise your hand. And again, for the record, we have no hands being raised. As jurors, you are being asked to make very important decisions in this case. You must not allow any personal feelings, sympathy, or prejudice or bias, whether conscious or unconscious, to influence your decision-making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Unconscious bias is a term used by social scientists to describe the reality that everyone has feelings, assumptions, perceptions, fears, and stereotypes, that's unconscious biases, that we may not be fully aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Our biases can affect how we act favorably or unfavorably towards someone. You should make every effort to be aware of your unconscious biases and what effect those may have on your decision making. Your verdict must be based solely on the evidence presented. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by bias for or against any party or witness. Do any of you feel that your personal views concerning this type of case or the parties involved might affect your ability to be fair and impartial? If so, please raise your hand. For the record, we have no hands being raised. Before I turn this over to the attorneys to ask questions for you, I always ask if anybody has a substantial hardship that would not allow you to participate in a one-day jury trial. And before I get 17 hands going up, I recognize that it is an inconvenience to be here, but what I'm looking for is an actual substantial hardship. And I like to give examples what would be a substantial hardship for me, but I understand that we're all individuals here, and so if you have a substantial hardship after hearing what mine are, then you would let me know and I would evaluate those. So for me, if I had non-elective surgery, so emergency surgery or surgery scheduled for later today, and I'm going to miss that by being a juror, that absolutely would be a substantial inconvenience, or a substantial inconvenience. I've missed my words. Anyways, that would be a problem. If I had non-refundable airline tickets today, and I'm going to miss those flights because of this trial, that might be. I would have to know more information. I'd have to know where I'm flying to, when I could get a connecting flight, how much of a financial hardship it would be. So that's kind of the difference between a normal inconvenience and a substantial hardship. And so what we're looking for, because we understand it's an inconvenience, you're all giving up a day of work, a day of your life to be here with us, that's an inconvenience. But we're looking for a substantial hardship to see if anybody cannot serve on a one-day jury trial. And the attorneys have told me that it is a one-day jury trial. And so with that understanding of where I am and understanding you all are different than me, do any of you have a substantial hardship that would not allow you to be a juror today? If so, please raise your hand. And for the record, we have no hands being raised. In just a moment, the lawyers will ask each of you questions. The purpose of their questions is not to argue the case or to embarrass you, but rather to determine your qualifications to serve in this specific trial. So please respond to the lawyers' questions honestly and sincerely, and if you do not understand a question, please ask the lawyer to restate it. So we'll start, Ms. Denniston, with you or Mr. Holman? All right. Go ahead, sir.
Thank you, Your Honor. Good morning, everybody.
Good morning.
So, I actually like voir dire because it's the one time that I get to go first. And so excuse me if I take maybe a little bit more of your time than Mr. Amundsen does today. But I'm going to ask you some questions to try to aid in our selection of a jury. All right, so none of these questions are meant to embarrass or call out anybody. We're just trying to get people's thoughts, opinions, feelings. So, feelings. How's everyone feeling about jury duty today? Anybody excited?
First time.
First time? Okay.
First time.
First time. Kind of interesting, yeah. Anybody totally indifferent?
Maybe.
All right, just you. Nothing wrong with that. One other thing I want to mention is that we cannot call you by name today. So if I do refer to you at all personally, it's going to be by your number, not to dehumanize you. It's because we're required to do that. All right. So I want to get at something that is personal to everyone, which is how is it that you make decisions? Is it more impulsive, like you just go with your gut? Or is it more you want to see all the facts, you want to reason through the dispute and figure it out that way? And I'm just going to actually calling everybody. So, let's go from the top. Juror number 66, how would you say you make decisions?
I would want to know the facts.
And by the way, there's no wrong answer, and there's also no answer that's going to get you off this jury for sure. So we'll just start with that. All right, jury number 82.
The same. I like to see all the information.
Jury number 84.
Yeah, I like to see all the information. I used to base it all on, I used to be more impulsive, but as I've grown older, I've definitely like to have all the evidence in front of me.
Makes sense. Jury number 3.
I go by gathering all the facts before I make my own decision.
Jury number 59.
I can do both, to be honest. Sometimes I jump to conclusions, but kind of like you, I think I'm just learning to gather more information before I make a final judgment.
Juror number 4.
I'm in the middle. I like to know the information, the facts and stuff, but my heart also does lead.
Number 83.
Everything in front of me before.
24.
I would say more about the feelings.
Number 75.
Facts.
Number 78.
I think I've had a lot of training with bias and unconscious bias, and so I would say that I probably think that the surface doesn't always elicit what the many truths can be. There's a lot of complexities. So I like to have lots of information and then just do the best job I can with what I have.
I would say having the facts and the information.
I would like all the information.
Both. Situation.
Number 51.
Same, both depending on the situation.
Number 56.
About the same.
Number 60.
I don't want to look at the facts, but
48.
I too also.
So you already asked if anybody knows me, or Ms. Aniston, or Mr. Cobb, or Mr. Amundsen. I like to ask, does anybody here know each other? Small county? No? Has anyone here ever been employed by the district attorney's office or any law enforcement agency?
That state of Oregon, Oregon Youth Authority, that counts.
Oregon Youth Authority? Okay. Can you tell me a little bit more about that? Were you involved in cases? Or?
No, I have not yet.
Okay.
But as far as report writings, gather evidence, stuff like that, inside the correctional facility, that's part of the job.
Okay. Has anyone spent a lot of time around police officers? I know a few people mentioned on your questionnaires that you had friends or family in law enforcement, so that a little bit. Do you have a friend or a family in law enforcement?
Both. I have a friend that's been my friend my entire life, and I have several family members that are in law enforcement, as well as I used to work in the emergency room and spent a lot of time around law enforcement when they brought people in.
My daughter and son-in-law are friends with police officers up in Portland, and I know one of them and his family pretty well.
Yeah, I got some friends.
I have a cousin that's
Yeah.
married to a police officer.
Yeah, I do have friends in Marion County and Lynn County.
Wife's uncle.
with the Red Cross, I work with them quite a bit on different scenes.
So, I mean, in your experience with police officers, many of you have experience with family and friends. So, what we're really getting at here is, do you find that police officers can make mistakes with anybody else?
Yeah. Mm-hmm.
Do you think that having friends, having family who are police officers or having contact with them for work purposes, do you think that that would cause you to lend any additional weight to their position?
A friend that are parole officers.
Do you take any kind of courses in criminology or criminal justice? Surprising. All right. So we're going to talk a lot about the internet today. So what's the internet? Someone? How about, can you define what the internet is?
The World Wide Web. You can share information quickly. It's hard to take things down once it's up.
Okay.
Yeah.
So let's get at that a little bit more. I mean, it's hard to take things down once they go up. Did anything ever really go away once it's on the internet?
Never deleted.
No.
Mm-mm. It hits the cloud and it's there.
Does anybody here watch YouTube?
Yep.
That's familiar with it?
Yep.
Do you have any kind of favorite content to watch? What's your favorite YouTube things to watch?
Spidey's. My grandchildren watch Spidey Friends, Cocomelon. I watch kitty things on YouTube. Sorry.
Yeah. Many of us kids do. Anyone else have like a type of content they like to watch on YouTube?
Mr. Beast.
Sports.
Mm-hmm.
Basically everything's on.
Mm-hmm.
My son watches a lot of different things on YouTube, like different commentators and stuff, like Mr. Beast and whatnot, and then a lot of TikTok.
Those commentators, what are they commenting on?
He watches different ones where they comment on different things that they find online, their opinions or what they've figured out about things, and it's kind of like they just give their opinions on different things. And he watches one that follows like movies and talks about different things in movies.
Do you think people online take on an entertainment persona?
Yeah.
So on YouTube, I think people take on.
Mm-hmm.
Anyone here done any acting?
In high school.
All right. Is anyone here familiar with Dropbox?
But I use it through for plans.
Can you explain briefly what Dropbox is?
Basically, it's a large folder where you can share the files.
Files.
Yeah. Some server. I have no idea.
So if someone got access to your Dropbox.
I suppose. I mean, most of the time, people grant me the access.
So I don't know anything further than please give me access.
Okay. Dropbox as well.
Vaguely share files here and there with people on team that I manage.
Every website has terms and conditions, right? Anyone read those? Partially.
Thank you for it.
Same, honestly. But terms and conditions, you have to agree to them to use the website. You understand that you're agreeing to use time. You're familiar with Snapchat? Can you explain what Snapchat is briefly?
It's just it's a way to kind of give people like a glimpse into your life for a very brief period, whether it be a video or a picture, and it has a bunch of different filters that you can do to change like your face or the picture itself, and you can message people back and forth through direct message. But a lot of Instagram, a lot of them are like that too, but they're all just a tiny bit different. But yeah.
Is there a mechanic on Snapchat where
I believe so, yeah. Every 24 hours. I think at the end of 24 hours they have that one. And anyway, cool.
And I would open this up to anybody, but is there still a risk even to send something out?
Yes.
During 24 hours. Anybody have any particular feeling on sharing intimate images?
Smart idea.
Well, it's going to be on there forever anytime you send it out.
I would say, why?
I think some people do.
Yeah.
A lot of people do.
Mm-hmm. Yeah.
Has anyone ever had an image shared that they didn't want shared in their own life? Yeah? You have to explain any details.
Yeah, when I got locked up in Multnomah County, my buddy actually shared like on Facebook my mugshot. So needless to say, we're not friends, but.
I was about to ask that, but.
Yeah.
Not a picture, but information. Well, not myself, but like information about a family member publicly shared that was inappropriate.
Are they familiar with the website OnlyFans?
It's a website that I believe it's a website that people can like join and they can pay money to be able to see intimate pictures of people.
You don't have an issue with that kind of content?
I don't think it's a smart idea.
Do you want to expand on?
Well, I'm not a tech person or a get on a website or anything, but I'm just thinking stuff's private. Why you want to share it publicly or especially intimate stuff? It's like that's yours. I mean, that's something affecting everybody for one thing. Peddling, I guess, then.
A little bit from that. So, Anybody here like to play video games? Did you mention? Yes.
I said when my child forces me.
I think Journal 53, did you mention that your spouse is a artist?
Mm-hmm.
So that's a game company, right?
Mm-hmm.
So do you play?
Yeah.
Are you familiar with Discord?
Mm-hmm.
Or is anyone else? Can you explain what Discord is?
It's similar to Skype. You can join calls, video calls or voice calls with people. There are servers with multiple people with whom you can chat. You can send messages to people.
Well, I like dinosaurs, but it's kind of like chat rooms.
Yes.
All right. What do you think in general terms about a person who's standing trial? Do you automatically assume they're guilty? You don't automatically assume we're here. They must have done something.
They're there for a reason.
Okay.
Some sort of mistake. I mean, something went left instead of right to bring them to this point. Not necessarily guilty, but something went wrong to get to this point.
Yeah, so there's a difference between actual innocence and guilty beyond reasonable doubt. Do you have any thoughts on beyond a reasonable doubt? Do you know what that means?
I know what it means, yeah.
Hard question.
It's hard. That's a gray area.
So it's subjective, right?
Yeah.
Mm-hmm.
Everyone has kind of a different bar as to what a reasonable doubt is. So who drove here today? Okay. So parked your car, came in here, did your orientation, sitting here for 30 minutes. At some point, we'll let you go. You'll go back to your car. I swear. Do you have any doubt that your car is going to be there?
Yes. Even though I have a little pocket.
Totally fair. So what could have happened to your car? Towed or something?
I would hope not, because I'm parked in front of the sheriff's department.
That's evidence in your favor. So there is some doubt as to whether your car is going to be there. Does that rise to the level of reasonable doubt?
Doubting that our car's going to be there, or?
So reasonable doubt is doubt based on common sense and reason. And brings it into your subjective sphere. And so I'm not really going to go beyond that to try to answer that question for you. That's kind of the hypothetical. It lays it out there a little bit. So what if I told you the aliens had stolen your car? Car is gone. I'm like, aliens came. Took your car away. Is that reasonable? Do you think I have to back that up a little bit? Let me show you a picture of the alien.
I don't think I believe the picture either.
If they were illegal, maybe, yeah.
It's illegal aliens stole our car.
That's a
Okay.
reasonable.
So, and that kind of gets at the difference between types of evidence. So there's direct evidence, and there's circumstantial evidence. So direct evidence, a photo. Can anyone describe what circumstantial evidence might be?
Could you repeat that?
Anyone describe what circumstantial evidence might be? So, I'll give an example. So, someone just stepped into the courtroom. So, let's say someone had stepped into the courtroom and they had an umbrella with them. And they were taking out the umbrella. Water on the umbrella. Is that direct evidence that it's raining outside? Would you conclude from that it's raining outside?
Mm-hmm.
Circumstantial.
Something that would lead you to believe that's how that outcome happened.
Not proof.
Could have dropped
Or if someone came in and said, wow, it was just raining outside. Talk about one other thing. So, in addition to needing to prove this case beyond reasonable doubt, there's kind of another element to that, which is the burden of proof. And so, which side has the burden of proof?
Accuser. The one doing the accusation has to prove, has to back it up.
And who is that today?
The prosecutor, right? The prosecuting.
So, what does that mean? If I were just to sit here and say nothing throughout the whole trial, and Mr. Amundsen put on evidence that you didn't believe that it proved the case beyond reasonable doubt, who wins?
Defendant.
So, is everyone comfortable with that concept? That really this is about whether or not the state can prove their case. Got any feelings about that?
About the state doing what?
Just, do you have any issue with the fact that this case requires the state to prove their case?
Isn't that what every court's supposed to do?
Instructed, if the defendant does not take the stand, that you can't hold that against them. Anyone here have a problem with that?
If he can't take the stand? Can't give a defense for himself?
If he does not take the stand,
Oh, if he chooses not to?
you'll be instructed you can't hold that against him. Do you have an issue with that?
Against the defendant? If he doesn't testify?
Yes.
No, that's just a choice. If he doesn't want to.
What are some reasons that someone might not testify beyond? How would you react if you found out that a witness lied or gave inconsistent testimony?
I think it's wrong to lie. It's wrong to lie, but depending on the inconsistency,
Well, they were on the stand, right? They took an oath. So I'd say they've caught in a lie. So whatever they've said is going to have to affect the rest of the case, yes.
All right. So one more, just, is there any question that I could have asked that you can think of that would have been like the question that would tell me what I need to know about you on this truth?
One second, Mr. Holman. Juror 84. Sir, you made a comment that an acquaintance or a friend of yours sent out a photo when you were in Multnomah County Jail, a mugshot.
Yeah.
Were you convicted of any crimes based on that situation?
No, it got lowered from like a misdemeanor to like a violation.
Okay, so no felony convictions or misdemeanors
no.
within the last 5 years? Okay, all right, thank you. I just had to verify that you were eligible to serve as a juror. Thank you, sir.
No worries.
I accept it. Mr. Amundsen?
Thank you, Your Honor. All right, I just want to thank everybody first for being here. Mr. Holman asked a lot of the questions that I was planning on asking, so I'm just going to ask a few follow-ups and kind of cruise through things, and that way we can get started. Does that sound good?
Mm-hmm.
So, like you said, like you've already heard, my name is Connor Amundsen. I represent the state today. And the first thing I want to ask everybody is, does anybody have any strong feelings about social media? Yeah? What are those?
I extremely dislike it. A lot of it's misleading. There's a lot of hate. There's a lot of anger that goes around.
Raise your hand as well.
I think a lot of people hide behind social media. They think it's kind of two ways. People think they're safe on social media, but then there's a lot of people that take advantage and use social media thinking it's okay because they're hiding behind a computer. And so either nobody knows who you are or they just have distanced themselves, so they don't really think of the repercussions of what they do.
Kind of like they feel like they can get away with more stuff because they're protected by that separation.
Yep.
Does anybody else agree with that?
That's a good point. But I think also, too, once you understand what the social media, I know what's a lot of it, what's behind it, and it's not good.
Mm-hmm. What do you mean by that?
Well, information's coming out that it's been controlled by, it was set up for the very purpose of spying on people, gathering information. That's evidence that's been proven and being shown. So for me, and I've tried to warn my kids, stay off. Because their connection with China, connections with 3-letter agencies in our country, it's just, it's in the news. It's being used for getting information on people, finding out about things, and whatever reasons else they're using the information for. So for me, not only is it not smart, I think it's really risky. Kind of like you said. It's just risky.
People could be impulsive and they don't think about their actions. You hit a button, it's out there, and then it doesn't matter. You hit that button and go, oh crap, it's a little too late. You've already put it out there.
Yeah. So, actually, just kind of following up on that, who here sends text messages or emails or anything? Yeah. Okay. I figured everybody would probably raise their hand. So, I'm married. I text my wife, right? We talk throughout the day, especially when I'm like gone for a work trip or on vacation with my family yesterday, something like that. Has anybody ever sent a text to their spouse or a close friend or anyone that was only meant for that one person? Maybe it was something private about yourself. Maybe you were letting off steam and venting to that person, whatever it may be. Would anybody be surprised if that person, your close friend or your spouse or anybody, posted that on Facebook for everybody to see?
The problem.
What was that?
If it's a
That'd be a problem.
individual.
Yeah. Why would that?
You'd lose their trust. It's supposed to be private between the two.
Right. Okay. So Does anybody else have any feelings about that? Why would that be? Does anybody disagree that it would really bother them or would really be an issue? Yeah. Yeah.
Like maybe I don't care, like I am in a bad mood and I let you know. But, you know, it happens, right? If I told you my deepest, darkest secret, and then you
Would you be surprised if somebody else who you didn't know or didn't know very well posted that message online? Would it bother you more? Less? Same?
More.
More? So, just as another hypothetical, let's say you're in a public place, a park, a mall, something like that. Just walking around, maybe you got your kids with you if you've got kids, or, you know, whatever you're doing. And you get home later, maybe the next day even, and you get on Facebook or Instagram or whatever social media platform you want to use, and you see a picture of yourself pop up. Anybody feel comfortable with that? Feel uncomfortable with that?
Uncomfortable.
Yeah.
So weird. I have to say because my sister-in-law posts pictures of like family things, so that doesn't bother me. But it would be the
From someone you didn't know. I should have probably clarified that.
That would be creepy.
Yeah. Okay. Would anybody not be uncomfortable with something like that?
I think it would be creepy, but I would rather have people that I didn't know looking at that image than people that knew me.
Okay.
I think it would be creepy, but I would be like, then nobody knows that's me but me.
why are you posting me?
Right.
It depends if you're in the background compared to if it's a direct picture of you and they don't know you. And
yeah, that's a good distinction as well.
yeah,
Especially in the age of social media, and everybody sees pictures of each other all the time, stuff like that. Okay, so the next thing I want to kind of follow up on is, Mr. Holman spoke a little bit about direct and circumstantial evidence. So, circumstantial evidence is evidence that we can use to infer a fact about the case. So, I don't have any kids, but I have a whole slew of, I'm the oldest of a slew of cousins. How do you know, does anybody here have kids? Yes. Okay. How do you know that they have a poopy diaper?
You know, smell.
You smell it? Okay. So, you didn't see it, right? You always
would be gas.
That's true. So, anyway, even without seeing it, and you usually do, not usually, sometimes you can smell it before you see it, right? But you can infer what's potentially happened based on smell, right? Mm-hmm. And so, one of the things we're going to talk about today is intent, right? What someone's intent was. Do you think that we can use circumstantial evidence to determine someone's intent? Would it help if I threw out a hypothetical out there for you guys to consider? Yeah? Mm-hmm. Okay. So, it's late at night, you're walking home, you walk by your neighbor's house, it's pitch black, you see somebody outside, they're wearing a ski mask, they've got a crowbar in their hand, and they're kind of like looking through the windows. What do you think that person's doing?
Tasting the joint.
Yeah.
Something not good.
You know for sure that's what they're doing?
No.
They're not gardening.
It's suspicious.
Unless they're pranking someone in the house.
The only thing I'll say is that I would be cautious about wearing a ski mask. So I'm joking. So you don't know. You haven't seen them break into the house yet. But if they told you that they were just there to visit a friend, would that be reasonable?
No, there'd be no reason to have to.
Is it Halloween?
Yeah. Is it snowing
Not
outside?
Yeah.
Are they in Aspen and have a loose tire?
So I think, the point that I'm kind of working around here is that we can use facts like that to infer what someone's intent is, even if they don't say, hey, just so you know, stranger walking by, I am going to break into this house. That's my plan, right? So reasonable doubt, does everybody understand that reasonable doubt doesn't mean beyond all doubt? Kind of along the same vein, Mr. Holman explained that reasonable doubt is doubt based on common sense and reason. It seems like everybody's pretty comfortable with that, so. Okay. So one of the last things I want to touch on is, Mr. Holman mentioned an entertainment persona and entertainment personas that people have online. Do you think that does anybody here think that people can take that too far?
Yeah, absolutely.
Anybody not agree with that? Anybody have anything they want to add?
So, folks, the process of deselecting jurors, the attorneys and I are going to go back into chambers and deselect jurors. This process takes us approximately 5 to 7 minutes. What I need you all to do is stay where you are at, because how we know who is whom is by our map and your juror numbers. And if you swap places with someone next to you, you might end up on the jury if you're not supposed to be, or you might end up off the jury when you're supposed to be on the jury. And so please just stay put. You could stand, move around, stretch your legs, do things like that. But we will be back in about 5 to 7 minutes to deselect jurors and then move on with the trial. So if I can see counsel in chambers. So folks, before I excuse a number of jurors, I want you all to know that each side is allowed to excuse a certain number of jurors. If you are excused today, you should not feel that your attendance has been without value. The court needs a substantial group of available trial jurors so that an impartial jury can be selected. All of you here today have provided an important contribution to this process, and your presence assures fairness. And folks, the way that I'm going to move people around is I try to get folks to step over each other as few times as possible. However, it's inevitable. I'm going to have some of you stepping over each other, so I do apologize. And so what will happen is if you are seated in the soft seats when we're done moving people around, you're staying with us. If you're in the hard seats, you're excused for today. Your jury service is complete. And so the folks that are currently in the hard seats, you all are excused for today. Thank you for your service. Juror number 83, you are excused today. Thank you for your service. Juror number 4, you are excused today. Thank you for your service. Juror 59, you are excused today. Thank you for your service. Juror 82, you are excused today. Thank you for your service. And juror in seat number 1, juror number 66, you are excused for today. Thank you for your service.
No, you're fine.
So now is where I'm going to have some of you in the front stepping over everybody else. And so the person in seat number 1 will be juror number 75. And so juror number 75, you're going to take seat number 1, so 1 back and 1 over. In seat number 2, it will be juror number 78. It's really tight and there is not much room, so I apologize for that. And juror in seat number 5 will be juror number 62. And then juror in seat number 6 will be juror number 53. And sir, you are excused for today. Thank you for your service. The 6 of you will be our jurors for this trial. If I can get the 6 of you to please stand, raise your right hand. My assistant's going to swear you in with your next oath.
Do you and each of you solemnly swear or affirm you will try the matter issued between the state and the defendant and a true but according to the law and evidence is given on the trial, so help you God?
Yes.
All right, thank you. You may be seated. So, folks, next I'm going to read a precautionary set of instructions to you. This will take us just a few minutes. After that, we'll have our morning break. In our morning break, we have a jury room right back here. There's water, there's a bathroom, most importantly, and there's coffee, soda, things like that. Help yourself to whatever's back there. But I want to get through the precautionary instructions before we take any breaks. So members of the jury, I will now explain some of the rules that apply during a trial. There are 8 stages to most trials, and I'll briefly explain each stage. The first is jury selection. That's what we just completed. The second is explanation of the general rules. That's what I'm doing now. The third is opening statements, and this is when the attorneys summarize what they expect the evidence to be. The fourth is presentation of evidence. This is when witnesses and exhibits are presented. The fifth is closing arguments, and this is when the attorneys have the opportunity to persuade you how to decide the case. The sixth is jury instructions, and this is when the judge explains the law that applies to the particular charges in the case. This includes explaining what the state must prove beyond a reasonable doubt for a guilty verdict. You will receive a printed copy of the instructions for deliberations. That takes us to the 7th stage, and that's deliberations. This is when you go back into the jury room and decide whether the defendant is guilty or not guilty. The 8th is when you return the verdict, and this is when you tell us what the verdict is. I will explain in a moment what is and what is not evidence. It is extremely important that you consider only evidence in deciding the facts. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision-making. You must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Unconscious bias is a term used by social scientists to describe the reality that everyone has feelings, assumptions, perceptions, fears, and stereotypes. That's unconscious biases that we may not be aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, how we interact with others, and how we make important decisions. Our biases can affect how we act favorably or unfavorably towards someone. You should make every effort to be aware of your unconscious biases and what effects those may have on your decision making. As a judge, I am a gatekeeper regarding evidence. I determine what the law allows to be evidence. You may not consider anything that is not evidence in deciding the facts. However, the law does not conclude that anything that is evidence is necessarily reliable. Determining the reliability or believability of evidence is ultimately your responsibility. You must decide what evidence is believable and how believable or persuasive any particular piece of evidence is. So while you're not allowed to consider anything that is not evidence in deciding the facts, you are free to decide how believable or unbelievable, important or unimportant any particular piece of evidence is in deciding the facts. Evidence consists of testimony of witnesses and exhibits that are admitted into evidence. Testimony is what a witness who has sworn or affirmed to answer questions truthfully says while being examined as a witness. Exhibits are physical objects, such as photographs, charts, or letters. You will be able to examine admitted exhibits during your deliberations. You may draw reasonable inferences from the evidence, but do not guess or speculate. In understanding what is evidence, it's helpful to have some examples of what is not evidence. The fact that a criminal charge has been filed against the defendant is not evidence. Any defendant is innocent of any crime unless and until the state proves the defendant's guilt beyond a reasonable doubt. Questions from lawyers or non-witnesses, for that matter, are not evidence. So whenever I sustain an objection to a question, do not speculate about why the question was asked or what the answer would have been. That is a subtle but important point. In our everyday lives, if a friend asks us if we have seen our mutual friend's new car, we infer from the question that the mutual friend has a new car. However, it's not the same in trial. The person asking the question is not a witness and is not subject to the safeguards that the law requires before you may consider a person's words as evidence. So in court, you are not allowed to consider questions asked by attorneys or non-witnesses in determining what the facts are. Those questions are not evidence. Of course, when a witness answers a question, you may consider the answer in the context of the question. So, for example, if a lawyer were to ask, was the traffic light red or green, and the witness answers green, you may take the answer as stating that the traffic light was green. However, if the witness answers there was no traffic light, you may not take the question as evidence that there was a traffic light. From time to time, a lawyer may object to something that is offered into evidence. I will decide whether the objected to material will be admitted into evidence. If I overrule the objection, the material, for example, an exhibit or the witness's answer to a question, becomes evidence. If I sustain the objection, the exhibit or the witness's answer is not admitted and is not evidence. You must not consider the exhibit or the witness's response because it is not evidence. Occasionally, I may decide that something that had been admitted into evidence should not have been. If that happens, I will instruct you to disregard the exhibit or testimony that should not have been admitted. This means that the material is no longer evidence. You must not consider it in any way. You must treat it as if the question had not been answered or the exhibit had not been received in the first place. You must not interpret any statement, ruling, or remark that I make during this trial as any indication that I have formed any opinion about the facts or the outcome of this case. You and you alone are to decide the facts. You must decide how believable the evidence is and what weight or value you will give that evidence. You may take notes if you wish during trial, and during the initial break, my assistant will hand out notepads and pens, or she will hand them to you when you come out of your initial break. However, please keep in mind that each party is entitled to the considered decision of each juror. Therefore, during deliberations, you should not give undue weight to another juror's notes if those notes conflict with your notes or your recollection of the evidence. Do not allow your note-taking to interfere with your ability to observe and evaluate testimony. Your notes may be in only two places: the courtroom or the jury room. You may not take your notes with you on lunch or overnight breaks, for example. My staff will make sure that your notes are safe and that no one has access to them in your absence. Do not discuss this case during the trial with anyone, including any of the lawyers, parties, witnesses, your friends, or members of your family. This includes not communicating with anyone by any other means, such as telephone, text messages, emails, internet chats, blogs, or social networking websites. Do not discuss this case with other jurors or look at any other juror's notes until you begin your deliberations at the end of the case, after you have heard all of the evidence and the arguments of the lawyers and been instructed on the law that applies to this case. Each of you must keep an open mind throughout the trial and must not attempt to decide this case until you begin your deliberations. Do not make any independent personal investigation into any facts or locations connected with this case. Do not look up any information from any source. Do not communicate any private or special knowledge about any of the facts of this particular case to your fellow jurors. Decide the case only on the evidence received here in court. Do not read any news articles or watch any or listen to any radio or television reports or read or listen to anything on the internet about this case or about anyone involved in this case. You also must not use any internet search engines such as Google or any of the others to look for any information about the case, the law that applies to the case, or the people involved in the case, including the defendant, the witnesses, the lawyers, or the judge. Do not use any map program or mapping system to attempt to view or locate any of the locations that may be discussed in this case. So in short, do not communicate with anyone by any means concerning what you see or hear in the courtroom, and do not try to find out more about this case by any means other than what you learn in the courtroom. Decide this case only on what happens here in open court where both the state and the defense are aware of and have the opportunity to question the sources of the evidence and to address any legal issues that may arise. This is the only fair way to decide a case. If you base your verdict on anything other than what you learn in the courtroom, that could be grounds for a mistrial, which means that all of the work that you, your fellow jurors, the parties, the lawyers, or the judge have done will have to be done all over again. That is why this is so important. Ignore any attempted improper communication. If any person tries to communicate with you about this case, tell the person that you cannot discuss the case because you are a juror. If that person persists, simply walk away and report the incident to the court. You may not talk to anyone about this case, even the people closest to you, except to say that you're jurors on a criminal case and Judge Casso says you cannot talk about it. And I like to point out that we are in a very small jurisdiction. So when we go break for lunch or do things like that, you may see the attorneys or me or my staff in the hallway. The attorneys and I will not talk to you because those are the rules of the court. And so do not take that as a slight. They're required by me not to talk to you all because we don't want to have a mistrial. And so please don't think they're being rude or I'm being rude. It's just the rules that we live by. After you have rendered your verdict or have been otherwise discharged by me, you will be free to do any research you choose or to share your experiences with anyone you choose, either directly or through your favorite electronic means. Remember that all phones, laptops, and other electronic devices must be turned off while you are in court and while you're in deliberations. After our morning break, we will hear the opening statements in which the lawyers will outline the evidence as they expect it to be. After the opening statements, the evidence will be presented. At the conclusion of the evidence, the lawyers will make their closing arguments to you. I will then instruct you on the law that applies to this case, and you will begin your deliberations. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not have a written transcript to consult. So I urge you to pay close attention to the testimony as it is given. If at any time you cannot hear a question or answer, let me know immediately by raising your hand. In performing your role, you must, of course, be fair and impartial. You must follow the law whether you agree with it completely or not. And you must not allow yourself to be influenced at all by personal feelings, sympathy for, or prejudice against anyone involved in this case. So, folks, those are our precautionary instructions. We are now going to take a 15-minute break so people can use the restroom, get some water, coffee, soda, whatever you want. As you leave the jury box, you're going to head that way. You're going to notice there are 2 black steps right there. They hide in the black carpet. Be careful as you step out of there. When you come out of the jury room, when my assistant gets you, take note of where you are currently seated, because if you come out in that order, then you don't have to step over each other. And so that's my pro tip for being a juror. And so with that, we'll be in recess if you want to head back into the jury room now. Okay. Still go back on the record. All right. So, Mr. Cobb, before trial, your attorney handed me a notice of law student appearance consent that you had signed. So I've signed that to allow Ms. Denniston to also work on this case. Okay. And then also, your attorney handed me a venue waiver that you had signed with your attorney. And I just wanted to put on the record that your attorney handed me those things. Okay. And then we're addressing them now so the jury cannot hear that these things were going on. But I just wanted to let you know that I did receive those documents and accept them, and they will be part of the case. Okay, sir? And then we'll be in recess for 15 minutes. Let's come back at 20 till. Parties ready for the jury?
Yes, sir. Yes, sir.
We'll bring in the jurors. Members of the jury, you will now hear the opening statements of the attorneys. Mr. Amundsen, you may go first.
As you've already heard, today the defendant is charged with unlawful dissemination of an intimate image. I represent the state, so I have the burden of showing 5 things. Excuse me. First, that this happened on November 19th, 2022. Second, that the defendant caused to be disclosed an identifiable and intimate image of Stephanie Loggins. That when he did that, his intent was to harass, humiliate, or injure her. That she was harassed, humiliated, or injured. And that a reasonable person would have been harassed, humiliated. I'm only going to call one witness today. And that's the victim, Stephanie Loggins. And what she's going to tell you is that on November 19, 2022, she was online hanging out with some friends. And then she started to get messages that another person was live streaming on YouTube. And on that live stream, he was showing a picture of her, mostly nude, to everybody who was watching his live stream. Now, she's going to tell you she never wanted him to have that picture, that she never sent him that picture, and that she certainly never consented for him to show it to everyone on the internet. In fact, what she's going to tell you is that she's part of a community on YouTube. That she does live streams, and that the only relationship she has with the defendant is that he is a part of the same community. Ultimately, what she's going to tell you today is that someone she barely knows got a hold of an intimate photograph of her, got online, and showed all of his followers that picture. And she will tell you that yes, she was humiliated, she felt harassed, and you're going to see the video today. Now that video was taken, you're going to hear that video was taken down, but that someone was able to save a clip of it before it was removed. Now the video is edited and a little choppy, but what's on it is pretty clear. You're going to watch as the defendant sits in his car, laughing, making fun of her, making fun of Stephanie, Miss Loggins. You're going to see him show the picture more than once of her. You're going to hear him call her a dumb bitch. Now, after you've seen all the evidence today, I'm going to stand up here again in front of you. And I'm going to ask that you find the defendant guilty of unlawful dissemination of an intimate image. Thank you.
Ms. Denniston.
Morning. Today, you're going to hear evidence that Stephanie Loggins recorded an intimate video of herself several years ago, and that she sent that video to at least one individual. You also hear evidence that she disclosed this video to the public on a live stream she appeared on sometime prior. You hear that after she disclosed the video online, someone other than Mr. Cobb produced a number of screenshots of that video and distributed them on the internet. You'll see that over a year ago, Miss Loggins is fully aware that her photos were everywhere on the internet. You hear evidence that Miss Loggins and the defendant in this case are both members of the same YouTube community. We're asking you to evaluate this evidence to the very high standard held in these types of cases, proof beyond a reasonable doubt. We ask you to use common sense and evaluate each and every piece of evidence you hear today. At the end of this case, we will ask you to find Mr. Cobb not guilty. Thank you.
Amundsen, call your first witness.
Your Honor, State calls Stephanie Loggins.
Come on forward. I'll have you come around the left side of the table. Once you pass the table, raise your right hand to be sworn in, please.
I don't take perjury to solemnly swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Ma'am, please have a seat in the witness stand. Once you are seated, you'll tell us your first name, your last name, and then spell your last name for the record.
My name is Stephanie Loggins, Loggins.
Mr. Amundsen, you may inquire of Ms. Loggins.
Ms. Loggins, do you have any hobbies?
Yes. I spend a little time on YouTube, where I have a YouTube channel.
Okay, and can you kind of explain what you do on YouTube?
It's commentary on a group of people that create a community on there.
Okay. So, what kind of community is it? I mean, what kinds of people do you talk to? What do you do when you're on there?
It started with true crime. They talk about true crime cases. And then one person will do a video, and someone will respond to that, and back and forth.
So you kind of called it a community. What did you mean by that?
There's hundreds of people tied to it. There's live chats when you do a live stream that they can participate in. And it moves on to other platforms where everybody's in touch.
And so for someone who might not know, what is a live stream?
It's where you can go live on YouTube. And YouTube's a public platform, so anybody can see it. And then you're live on camera.
And do you know Douglas James Cobb?
Yes.
And how do you know him?
Through YouTube. He has a YouTube channel as well.
Okay. And what kind of relationship do you have, or did you have, prior to the incident?
We've never been friends. I've run into him in chats and on panels, because you can panel with people during live streams as well. You can share them with other people.
Okay, and can you kind of explain what that means?
They can put out a link, and you can take it, and you will go up on the live video with them.
So, did you know him well? I mean, what kind of...
No, we've never been friends. I don't know him at all.
But did you know of
Yes.
him? Okay, and did he know
of me? Yeah.
you?
Yeah, he has a public YouTube channel, so anybody can see it.
So you said he has a YouTube channel. What kind of YouTube channel is it?
He has two. He has one where he reviews tools, and then he has another one where he does a lot of driving around and talking on camera.
Okay, so when you say talking on camera, some like just commentary?
Yeah, on people that we know on YouTube.
Okay.
Other people.
Has he ever talked about you?
Yes.
Okay, and do you remember when that happened?
November 19th.
Okay, and what were you doing that day?
I was on another platform, hanging out with a group of people from the internet, just talking. And someone let me know that he was live on his channel, doing what he was doing.
What was he doing?
He was pulling up a photo of me on his phone and putting it in the camera.
And what was that photo of?
It was of me in my left breast with that had been put out.
Okay, and so what did you do at that point?
I freaked out a little bit. There's nothing I could do. I watched.
So you watched it?
Yeah.
Okay. Would you be familiar with it if I showed it to you
Yes.
today? Your Honor, permission to publish what's been previously marked as State's Exhibit 1.
Denied.
Your Honor, State moves to have what's been previously marked as Exhibit 1 entered into evidence.
Any objection?
Yes, objection on lack of foundation.
Sustained at the moment. You need foundation, Mr. Amundsen.
I'm sorry, Your Honor?
You need foundation, Mr. Anderson. Amundsen, I apologize.
Ms. Loggins?
Yes.
Did you ever, is that YouTube video still online?
No.
Were you able to get a recording of it?
Yes.
And would you be familiar with that recording if I showed it to you?
Yes.
Okay, and where did that recording come from?
I had a recording of it. Multiple people have a recording of it now, since it was done very public.
Your Honor, State moves to have what's been previously marked as Exhibit 1 entered into evidence.
Objection now.
Yes. Any objection there, Ryan?
Of foundation.
Yes. There's a sidebar.
Members of the jury, I'm going to need to send you out to the jury room for a couple minutes. Go ahead, Mr. Holman.
Thank you, Your Honor. So in this case, this video was provided to Ms. Loggins allegedly by a third party. That third party is heard on the full version of the video making a hearsay comment about this case. The video and the evidence is a screen recording reportedly made by a police officer who's not testifying today. So this is a recording of a recording, possibly of a recording of a live stream that is no longer publicly available. There's a serious issue with essentially every element of the chain of custody here. The seizure was again provided by an unknown party. Storage. Prosecution can't prove this video was stored in a way that it could never have been tampered with at any time or altered. There have been 2 versions of the video provided. The second, fuller version was provided only about 2 weeks prior to the trial. No evidence can be presented as to the officer's investigation into the authenticity of the video, any testing that was done to prove that it's Defense argues that without the officer here to testify, it's impossible to lay the proper foundation for this figure to be there.
Mr. Amundsen?
Your Honor, Ms. Loggins has already testified that she watched the video live, that she was given this clip of that video, that she can testify that it's going to be the same exact one that she watched when she was watching it, and that she sent it to the police officer. But she's going to be able to, she is going to be able to testify and has testified that she watched the video and that this is going to be an accurate, that this is an accurate recording. If and regarding the third-party statement, that has been removed from the video.
So you made your record. The court is satisfied that based on the representation of Mr. Amundsen that the final layers of foundation will be established. If not, it's a mistrial. The court will receive it. And you said it's Exhibit 1?
Yes, Your Honor.
All right, we'll bring the jury in. Exhibit 1 is received over objection.
Your Honor, permission to publish?
You may. sending pictures like this out to people. You shouldn't be doing that. Steph, you shouldn't be sitting up. I'm going to show it. Steph, you shouldn't be sending pictures like this out to people. Steph, you shouldn't.
Is that a fair and accurate representation of the video that you watched on
It is.
November 19th? Do you recognize the person in that video?
I do.
And who is it?
That's Douglas Cobb.
And is he sitting in the courtroom today?
Wearing a black shirt.
Now, do you recognize the photo that he was showing people?
I do.
And what is it a photo of?
It's a photo of me.
Would you be familiar with a copy of that picture as well?
Yes.
And also, Ms. Loggins, would you be, how did you know that that picture was of you?
Well, he identifies my name in it. I spend time on my channel on camera, so you can also see a tattoo that I have that is recognized. Everybody knows it's me.
And would you be familiar with the picture of that tattoo if I showed it to you?
Yes.
Your Honor, permission to approach.
Granted.
Witness. So, can you tell me what that first photo was of?
This is of my tattoo. When the officer asked me to send it to her, I sent her this photo. And then this is the photo that he showed.
Your Honor, state moves to have what's been previously marked as Exhibits 2 and 3 entered into evidence.
Any objection to 2 and 3?
That's orderly been shown.
Can't answer that question, Mr. Holman. I haven't seen the photos.
Question 8 of objection.
Granted.
Loggins, is the picture marked as Exhibit 3 picture that was allegedly shown?
It is.
I do have an objection to Exhibit 3.
Same reason as the prior objection to Exhibit 1?
Photo has been proven to be
Objections overruled. Court receives 2 and 3.
Ms. Loggins, how did you feel when you saw the video?
Humiliated.
And did you ever send that video to Mr. Cobb?
No.
Did you ever give him consent to show it to anyone else?
No.
Did you ever give him consent to show it to everyone on his YouTube page?
No.
No further questions at this time, Your Honor.
Cross.
Thank you, Your Honor. Good morning, Ms. Loggins.
Good morning.
So, let's talk a little bit about your YouTube channel. How many subscribers do you have?
Over 3,000.
Do you earn money from your YouTube channel?
It is monetized.
What types of videos do you post on there?
I don't know how you would describe it. I do commentary on a community. We talk about people that are also on YouTube.
And I think you stated earlier that you sometimes appear on live streams with other users. Is that correct?
Correct.
There are similarities between the types of videos and live streams that you and Mr. Cobb post. Is that correct?
We talk about the same people sometimes, but I don't know. Other than that,
Some of your viewers know who Mr. Cobb is, correct?
yes,
Likely you share at least some portion of your viewership with Mr. Cobb, correct?
correct.
Did you watch his live stream live?
I did.
How many viewers did the live stream have on November 19th?
I don't know.
At least one of those viewers, other than yourself, was also a viewer of your own content, correct?
Correct.
You stated that the photo that is now in evidence is from a video that you created. Is that correct?
Yes.
But how long ago did you make that video?
2 or 3 years ago.
What was the purpose of that video?
I was in a relationship with somebody not on the internet, and I made that privately for someone.
How many people did you send it to?
1.
Isn't it true you told the police you sent intimate photos and videos to multiple friends?
Objection, Your Honor. Matter for the court.
Mr. Jury, I'm going to send you out.
Your Honor, my objection is to relevance as well as more prejudicial to probative under Rules 401 and 403. Whether Ms. Loggins sent this to another person or several other people is not relevant because Mr. Cobb, she's already testified that she never sent it to Mr. Cobb, and more importantly, she never gave Mr. Cobb consent to share it with everybody online. Unless Mr. Holman has some evidence that I'm not aware of that shows that she was selling it for commercial purposes or sent it directly to Mr. Cobb and gave him consent to share it with everyone on his YouTube page, any discussion of who she sent this to or how it got or how Mr. Cobb ended up with it would only confuse the jury, causing them to think that possibly if it had been leaked prior, that would be giving him, the defendant, consent to share it with people on his YouTube page, which is not within the statute.
Mr. Holman.
Your Honor, I would argue that the relevance here is that this is a case about disclosure and essentially who disclosed something is a material element here. In addition, if, for example, everyone who was on Mr. Cobb's stream had already seen the photo, then there was no disclosure.
Your Honor, I find
Hold on, don't interrupt.
My apologies, Your Honor.
Go ahead, Mr. Holman.
For now, that's clear.
Okay. Now, Mr. Amundsen, you may go.
Yes, Your Honor. I just wanted to know, I find it unlikely that there's going to be any evidence that every single person who watched Mr. Cobb's live stream that day had already seen the picture.
Let me look at the statute really quickly.
Your Honor,
Go ahead.
if I may, I believe that I'd like to direct your attention specifically to subsection 4, small f, capital A, and capital B, that specifically addresses the exceptions to disclosure, neither of which are applicable.
Don't have to remain standing. It's going to take me a couple minutes. It goes to you as well, Mr. Holman. If you want to stand, you can. May I see those documents, ma'am? Holman, do you have further argument?
I would simply argue that part of the statute is that Cobb knowingly caused to be disclosed an image that is separate from whether or not Ms. Loggins consented to that disclosure. So any argument about how the photo was disclosed is at least relevant.
So it's your argument that how many people Ms. Loggins gave this to somehow impacts whether or not your client knowingly disclosed?
Whether or not it was being disclosed.
Is there a different definition other than the definition to disclose that says includes but is not limited to transfer, publish, distribute, exhibit, advertise, and offer? Is there a different definition of disclosure that you have, Mr. Holman?
The argument I would put forward for that is that something can only be disclosed once. If it's already been disclosed to an individual.
Okay. All right. The objection is sustained. I don't find that definition of disclosure to be, I find it contrary to statute. And so the line of questions will not be allowed. We'll bring in the jury.
Thank you.
Young man, speak up. He's sitting at the paper and we can't.
Mr. Holman, if you'll pull the mic closer to you. Thank you. Juror number 75, thank you for letting us know that you were, or members of the jury were having a hard time hearing. Mr. Holman, you may continue.
Thank you, Your Honor. Are you familiar with the web service Discord?
Yes.
Discord is a service used to participate in chat communities as well as send direct messages to other users. Is that correct?
Correct.
What is your username on Discord?
It's S Steph with 2 H's. There's a few numbers after it, but I don't know off the top of my head what they are.
You're aware that the photo and evidence and other photos of you have been circulating online for more than a year, correct?
Objection, Your Honor.
Overruled.
I am aware that this image has been used to harass me for some time.
Can I approach with a document to help refresh your recollection, Your Honor?
May approach.
I'm approaching with what has previously been marked as Defense Exhibit 101. This image depict a private message thread on Discord.
It's a private message between me and someone else, yes.
In that image, do you acknowledge that this image has been everywhere?
No.
Does it appear from that image that you sent that user
Yes.
a photo that resembles the image in this case?
This is a conversation between me and a girl that I was very close friends with at the time. A private conversation.
And what's the date on that?
August 28th.
And you state in that chat the photos have been everywhere already. Isn't that correct?
I do. They were not on YouTube. They were not publicly shared until Douglas did that on a live stream. Once that happened, everybody got a copy of it.
You state you were surprised the other user hadn't seen it already, correct?
Yes. because of the circle that we are in.
That was on August 28th, 2022, correct?
Correct.
You're aware of how the website Streamable works, is that correct?
I am.
Is it true that once you provide someone with a link?
Objection, Your Honor. Relevance. The rules of Streamable have no relevances to any material fact of this case.
Mr. Holman?
Your Honor, one Your Honor, the statute specifically accepts photographs and videos that are created for a business or marketable purpose. And so line of questioning goes towards that.
Overrule the objection.
Is it true that once you provide someone with a link to a video hosted on Streamable, they can access that link?
No, there's ways to lock it so that it's set to private.
Isn't it true that once something has been disclosed online, it never really goes away?
Yes.
Are you familiar with the terms of service of the Streamable website?
I am.
And
Objection, Your Honor. There's to relevance. There's no the terms of service for the platform that was being used does not have any relevance as to whether or not the defendant had consent to share or disclose the photo.
Mr. Holman, do you have those documents?
Yes, Your Honor.
You'll approach with them so I can read them, please.
Do you have a copy for the court?
Mr. Holman. Members of the jury, I'm going to need to send you out for a moment. Mr. Holman, your argument.
Your Honor, our argument in this case essentially, or in this instance, essentially is that, as described on page 3 of the Terms of Service, Ms. Loggins did grant to Streamable the right, non-exclusive, royalty-free perpetual right to reproduce and display all the content she uploads to her Streamable account for business and marketing purposes. And in addition, that provided a similar non-exclusive perpetual right to display that content to provide the service.
Mr. Amundsen, further argument?
Yes, Your Honor. First, Streamable was not the one who distributed the photograph. Streamable wasn't the one who disseminated it. The defendant was. This document has nothing to do with how that has nothing to do with the defendant and his decision to show the photograph online. Moreover, the statute specifically says that exempts disclosure of images that were originally created for a commercial purpose with the consent of the other person. A clause that is buried in terms of service that say that the company whose streaming service you're using may reproduce and market things that you post there is very different from Ms. Loggins creating the image for the purpose of selling it.
Or for a different commercial purpose?
Or for using it for any commercial purpose. What she stated is that she created it for another person, and unless there's some evidence that I'm not aware of, I don't believe that there's any evidence that Ms. Loggins ever created this picture or these videos for a commercial purpose.
Holman, do you have a good faith belief that there will be some evidence that this image or video was created for a commercial purpose?
Direct evidence to show that, Your Honor, but I think that goes to the weight, not the
So you believe you will have evidence or a good faith belief that there is going to be some evidence that these images were created for a commercial purpose?
I think that there will be evidence that the jury could use to conclude that.
Your Honor.
Yes, Mr. Amundsen.
If I may, I can't say specifically what Mr. Holman's referring to, but I would argue that if it's anything along the lines of them being posted and used for a commercial purpose by a third party or by the streaming service, that is very far removed from Ms. Loggins creating it for a commercial purpose. So.
I hear your argument. My question to Mr. Holman was very specific, and Mr. Holman has answered. And based on his answer, the objection will be overruled. If there is no evidence that this was created for a commercial purpose, this will be a mistrial.
I'm going to draw.
Okay. So then you're going to be withdrawing this question? All right. We'll bring in the jury. The objection is sustained. Mr. Holman, move on.
Thank you, Your Honor. Do you recall appearing on a live stream on November 26, 2022?
Not specifically, no.
Do you recall appearing on a live stream that was posted with the title The Settlement?
Yes.
Holman, will you pull that mic even closer to you? Probably closer than that.
Is that better? And you stated on that live stream that it was your fault the photos were made public. Is that correct?
I was speculating at the time, yes.
Do you recall a live stream you posted on your channel, which is posted with the title, "'Tis the Season, Come On Up"?
No.
Have you ever posted a live stream on your channel in which you play the clip that we've now seen in this courtroom?
Redacted, yes. You can't see the image.
Approximately how many times have you discussed this case on your channel or other live streams?
On my channel, few, but on other live streams, many.
How many times have you talked about Mr. Cobb in your videos or in other videos?
I don't know.
So, this is content for you. Is that correct?
What's content for me?
You've posted this video on your channel, and you
addressed what happened.
And you stated that your channel
I had
is
to address
monetized.
It was
correct?
Yeah.
You stated that your channel is monetized, correct?
Correct.
So you've been posting about this case to drive traffic to your channel?
No. I don't want attention from this.
You've talked about it many times on live streams and on your channel.
Many times what?
You just stated you have spoken about this case many times.
I've answered questions about it. I've been asked about it.
You recall stating on a live stream that an individual you referred to as Polly was responsible for distributing the photos?
Yes.
Mr. Cobb is not the same person as Polly, is that correct?
No, but Polly did it after Yoda did it on his channel. As far as I know.
Isn't it true that you appeared on a live stream on November 16th, 2022?
I don't know.
I'm going to approach with the document that may refresh your recollection.
Okay.
You may.
This appeared to depict a live stream on which you appeared.
That looks like me, yes.
Do you recall whether that live stream was on November 16th, 2022?
No.
Have you ever applied for a copyright of a photo?
No.
If we could have just a moment, Your Honor, we're trying to find something that may refresh your recollection further.
Your Honor, if I may, I have a matter to address with the court while they're finding the video. I believe that I have an objection to the video that they're about to play.
Sure, I'm going to send you back out.
My objection is the same. Rules 401 and 403. I believe this is along the same lines as we discussed earlier. It's really not relevant how the photo came into the possession of Mr. Cobb or how the photo was distributed, unless there is some evidence on that video, which I do not believe that there is, that Ms. Loggins had created the video for a commercial purpose or had sent it to Mr. Cobb and given him permission and consent to share it. I think that all this is going to do is confuse the jury and make them think that if she had given it to anybody else or that it had been leaked to a small number of people in her YouTube community, that means that Mr. Cobb had full permission and consent to share it, which is not what the statute states.
Holman? I don't know what we're getting at. All I know is that you're looking at something to refresh the witness's recollection. I don't know what the witness doesn't remember other than she participated in a live stream on a certain day. That was the last line of questions that she says she doesn't remember on. So what are we getting at?
So currently, I'm trying to refresh her recollection because I don't think that she's making any attempt to make contradictory or false testimony. However, she did state that this was not being distributed until after the dated issue, and this live stream was recorded prior to the dated issue.
Your Honor, if I may.
May.
And it may be a question for Ms. Loggins as well, but I believe what she was referring to was it's pretty clear that this photo was passed around in some manner prior to, because she never sent it to Mr. Cobb, somebody else was circulating it within their small community. When she said that it had not been disclosed, I believe that she has referred several times to they had not been disclosed to the broader public until Mr. Cobb's incident. I believe she said that on earlier in the cross-examination as well.
So I want to make sure I understand, because Ms. Loggins has testified that prior to your client's alleged live stream, this hadn't been on YouTube, it had been on other platforms prior to that date, and that Polly may have showed it after your client is alleged to have shown it on YouTube. And so is there something else that you're hearing that I'm not hearing?
Well, simply that if it was discussed on the live stream on YouTube prior to its disclosure, that would not be the first time, at least that it's existed. Ms. Loggins simply wants to clarify that testimony. I'm perfectly fine with doing that.
Okay. Well, I don't think we're in need of that at the moment. You can keep looking for that. Right now, we're not getting into what's in there. So your objection's overruled because we're not showing whatever they're looking at.
Your Honor, I would also object to the line of questioning about what she's discussing in the video as well. It's just for the same reasons.
All it's being looked at right now is to refresh someone's memory. The jury's not going to see it.
Yes, sir.
All right. So we'll bring the jury in. And if you want to ask a question, Mr. Holman, about what we discussed, you may do that to clarify that. But in my notes, I'm pretty clear on what she's saying happened.
And we do have the video on the flash drive. If she'd like to view that as a way of refreshing her recollection, we haven't been able to pull it up on the tablet.
Mr. Amundsen?
Your Honor, it may make the most sense, or at least I would suggest that Mr. Holman ask Ms. Loggins some more questions before.
Well, as of right now, it's an improper refresh recollection because what she's saying she doesn't remember is not what you're trying to refresh. And so if you want to ask some questions, then maybe you might need a refresh recollection. But as of right now, it's an improper refresh recollection. Bring in the jury. Objection sustained. Mr. Holman, you may inquire.
Is it possible that you appeared on a live stream on November 16th, 2022?
Possibly.
And did you discuss the photos that are at issue in this case in multiple live streams around that time period?
Yes.
And around that time period, was it your belief that an individual referred to as Polly was responsible for distributing the photos?
I was made aware that Polly had sent them to someone else privately. They shared that with me. They came to me and said, hey, he's doing this, but that was private.
Just going to review my notes here. You made a number of negative statements about Mr. Cobb on live streams. Is that correct?
I don't recall.
You recall referring to him as a puppy pounder?
No. I know others have.
Nothing further at this time, Your Honor.
Redirect.
Briefly, Your Honor. Ms. Loggins, on cross-examination, defense counsel asked you, Mr. Holman asked you if you had talked about this case after the incident on November 19th, 2022. Why did you do that?
Well, once it happened, and there were people who looked up to see that charges were filed, and it was talked about everywhere. So I was asked a lot of questions. I speculated on it.
So, when you speak about, like, so, okay, I'm sorry. When you were talking about this case, was it because other people knew about it?
Yeah.
And so, what kinds of questions were being asked of you at that time?
Why he did it, how I feel about it, what do you think's going to happen?
And how do you feel about it?
It's awful. I have a daughter who I had to sit down and have a conversation with about this. This wasn't supposed to happen.
And just to reiterate, Ms. Loggins, did you ever send that?
No.
To Mr. Cobb?
No.
Did you ever give him consent to share it with anyone?
No.
No further questions, Your Honor.
Ma'am, you may step down.
Thank you.
State's next witness.
State rest, Your Honor.
Members of the jury, I'm going to send you out for lunch. So I'm going to have you come back at 1:15. I would like you in the jury room no later than 1:15 because I plan on the attorneys starting at 1:15. Remember the precautionary instructions that I gave you. You cannot start deliberating or start thinking about the case. You can't talk to anybody, your loved ones, your hated ones, your family members, your employers. You can't tell them what we're doing other than your jurors in a criminal case, and Judge Casso says you can't talk about it. Remember that if we see you in the hallway, we will not talk to you because those are the rules of the court. But I'll have you, if you want to grab your items out of the jury room, you may do that. But we will be in recess until 1:15. And so if you want to head back there now, that would be fantastic. Mr. Holman, Ms. Denniston, do you anticipate putting on a case? You want to talk to your client more about it over the lunch hour?
I want to discuss it more, Your Honor.
Okay. So then, in your leisure, if you don't decide to put on a case or if your client chooses not to testify, then we need to go over jury instructions once we get back. So after having a conversation with your client, go over jury instructions so that we can modify those as need be. And then be back here 1:15, 1:15, and let's handle whatever matters we need to handle at 1:15. So now we can go back off the record. Thank you. You may be seated.
And, Your Honor, we do have a matter for the court.
You're back on the record, 22 CR 60445. Ms. Denniston?
At this time, we'd like to motion for judgment of acquittal, Your Honor.
On the grounds?
Part of the statute states that in order to paint an image, the nipple has to be depicted. In no testimony has there been stated that the nipple was depicted. Further, throughout the pictures that we have seen, it is not clear if the nipple is actually in the image or not.
Mr. Amundsen?
Your Honor, I think that I think the photo is pretty clear that there's a ring and that you can see the nipple in the picture.
Your opinion's not evidence, so you're telling me that in the photo, a reasonable juror could conclude that that's a nipple?
Yes, Your Honor. I also believe Ms. Loggins stated during her testimony and kind of described what she was wearing and that there was a ring around it.
I don't remember that testimony at all.
I could be wrong, Your Honor, but that is what I recall.
I just recall it being, she said it was her left breast, is what I recall the testimony being.
Tracy, can we pull up the FTR? We have Ian come in and pull up the FTR? Or have me listen to it?
Right now, I can rewind it.
Your Honor, if it's sufficient, the state's comfortable relying on the picture itself, that a reasonable juror could come to that conclusion based on the photo.
Well, I want to hear what she testified to. So we'll go off the record for a minute. So the court had an opportunity to review the testimony of the complainant. Her testimony was that the photo was of her left breast. It did not describe what she was wearing in the photograph, anything like that. The state has changed their argument or relying on the photograph itself. So for the record, that's state's exhibit or exhibit number 3. In the light most favorable to the state, a reasonable juror could find that that is a nipple. So the motion for judgment of acquittal is denied. Any other matters for the court? All right. Is Mr. Cobb going to be testifying today?
He is, Your Honor.
He is?
Yes.
Okay, Mr. Cobb, if you'll please stand up for a moment. No, not yet.
Okay.
So, sir, anytime an attorney tells me that their client is going to testify or not going to testify, I ask a few questions of their client.
Okay.
And so do you understand, sir, that you're the only person in this room that gets to decide if you're going to testify?
Yes.
And your attorney can't make that decision for you. The district attorney's office can't make that decision for you. I can't make that decision for you. It's you and only you. Do you understand that?
Yes, sir.
And, sir, do you understand that if you choose to testify, I will not instruct the jury that you have a constitutional right not to testify because you're choosing to testify? Do you understand that? Is that a yes?
Yes, sir.
Okay. And the only reason I'm asking if that's a yes is because sometimes on paper, uh-huhs and uh-uhs look the same, and I want to make sure I preserve everybody's rights. And so, sir, has anybody promised you anything or threatened you with anything to get you to testify today?
No, Your Honor.
Did you make that decision to your own free will?
On my own free will.
Okay. Then you may have a seat, sir. And then with that, let's call in the jury. Members of the jury, if any of you turned on your electronic devices, phones, laptops, PDAs, anything like that, please make sure they are turned back off. They must remain off while we are in court. And for the defense.
Thank you, Your Honor. The defense calls Douglas Cobb.
Mr. Cobb, if you'll please stand, raise your right hand. My assistant will swear you in.
Under penalty of perjury, you solemnly swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth.
All right, sir, if you'll come on up here, please have a seat in the witness stand. Once you are seated, you'll tell us your first name, your last name, and then spell your last name, please.
My name is Douglas Cobb. My last name is spelled C-O-B-B.
All right, thank you.
Mm-hmm.
You may inquire.
Thank you, Your Honor.
And Mr. Holman, if you'll pull the mic in.
Mr. Cobb, if you had an image that you knew was intended only for private, personal use, would you disclose it to the public?
Absolutely not.
No further questions.
Cross?
No cross, Your Honor.
Mr. Cobb, you may step down. Next witness.
Defense rests, Your Honor.
Rebuttal witnesses.
No, Your Honor.
So, members of the jury, I'm going to have to send you back out because what I need to do, this break is going to be probably about 15 minutes. I need to finalize, it might be 20 minutes. I need to finalize the jury instructions, so I need to meet with the attorneys, do that. Then once I finalize those jury instructions, I'll print up copies, and then we'll come back out and the attorneys will have an opportunity to do closing arguments. I will then advise you of the law that applies in this case, and we will start deliberations. But I need to go through and finalize those jury instructions, and that does take me a little bit of typing time. And so I do apologize that we're right back from lunch and right into that, but I need to get those things done. And so if I can send you all back to the jury room one more time. And then for the attorneys, we should be on about page 9 of the jury instructions. And I have already noted that on the cut and paste with the jury instructions, there's a lot of hyphens in there that shouldn't be in there. I've gone through and eliminated those. But I think it's some function of cut and paste that's doing that. I don't know if they're coming from defense instructions or state instructions or where, but I have caught, I think, all of them that I know of. So we're on page 9, functions of the court and jury. Any objections to that instruction?
No, Your Honor.
No objection.
Right. Page 11, evaluating witness testimony.
No objection.
No objection.
Page 12, modified evidence.
No objection.
No objection.
Page 13, inferences.
No objection.
Page 14, innocence of defendant, proof beyond a reasonable doubt.
No objection.
No objection.
Page 15, defendant statements.
No objection.
No objection.
Defendant not testifying, the court will not give that instruction as Mr. Cobb chose to testify. Page 17, direct and circumstantial evidence.
No objection.
No objection.
Page 18, non-expert opinion evidence.
No objection.
No objection.
Evaluating witness testimony, witness false in part.
I don't believe it's necessary, Your Honor. I don't believe that there were any false statements given.
I do think there were some inconsistencies in testimony. In my view, this instruction is really more to clarify. It does include that this does not necessarily constitute lying. So I think it's appropriate.
Court will give the instruction. The second part of that on page 19 is the criminal charge. Again, I believe that was a defense request. Is the defense still requesting the court to read the criminal charge again?
I think since it will already be read, it's not necessary.
Page 20, intentional and with intent.
No objection, Your Honor.
Page 21, knowingly and with knowledge.
No objection, Your Honor.
No objection. I did have a brief note. Are we using SL simply because it's consistent with the charging instrument language?
What the parties submitted to me.
Understood. No objection.
All right. Definitions, page 22. The court would remove where it says special instruction. But is there an objection to either of those four definitions or any of those four definitions?
No objection.
No objection, Your Honor.
Page 23 and 24, the defense gave an instruction and the state gave an instruction. Page 23 is the defense's instruction. Page 24 is the state's instruction.
Well, Your Honor, I think that there's clearly an error in the state's instruction, so we have no objection to using defense's instruction. I think...
You have reckless drive in there?
Yes, and I do not know.
I also note on the defense's instruction on number 1, it says that the date must be proven also in Polk County, Oregon, but there was a waiver of venue.
Yeah, I would ask that the in Polk County, Oregon be removed to avoid confusion.
That's a mistake, Your Honor.
Okay. And then with that modification, are the parties comfortable with the court giving the defense's instruction?
No objection, Your Honor.
Page 25, verdict.
And no objection to that, Your Honor.
And Mr. Holman, I didn't hear if you had an objection to that.
No objection, Your Honor.
And then with regards to the verdict form, it's standard verdict form with not guilty above guilty, a line for presiding juror number and presiding juror name. Any objection to the verdict form?
No objection, Your Honor.
No objection.
And I'll make the changes to the jury instructions. It'll take me probably about 10 minutes to make the changes to the instructions and print copies. So we'll be in recess until I complete that. Thank you. You may be seated. Counsel, were you able to look over the jury instructions? I don't think I missed any of the things we talked about, but I may have, so I don't think so.
Looks correct to the defense, Your Honor.
Looks correct to the state, Your Honor.
All right, and we'll bring in the jury for closing arguments. To the jury, we will now hear the closing arguments of the attorneys. Because the state has the burden of proof, they get to go first as well as last. So, Mr. Amundson.
So when we started this case, I told you that the state had a burden of proof. That I had proved beyond a reasonable doubt 5 things. That on November 19th, 2022, the defendant, James Cobb, Douglas Cobb, with the intent to harass, humiliate, or injure Stephanie Loggins herself, knowingly caused to be disclosed an identifiable image of her whose intimate parts were visible or was engaged in sexual conduct. That Douglas Cobb knew or reasonably should have known that she did not consent to that disclosure. That she was harassed, humiliated, or injured by the disclosure, and that a reasonable person would have been harassed, humiliated, or injured by the disclosure. So as far as the date, I don't think anybody here disagrees that November 19, 2022 was the date that this occurred. Now, there are a few things in that second element that should be addressed. First, that the defendant caused to be disclosed an intimate and identifiable image of the victim. You heard testimony from Ms. Loggins today. Importantly, you saw the video in which he showed everyone on his live stream a picture of Ms. Loggins. When he did that, he was disclosing that image to the public. He was showing everybody on his live stream, everybody who was watching, that picture. Now, if you look at the picture, you can see that it is indeed an intimate image of the victim. When you're given the jury instructions today, the judge is going to inform you and explain to you that what intimate means, and one of the things that it means is a female nipple, which can be seen in the photograph. Now, the other thing that the state's required to prove today was the defendant's intent, and his intent was to harass, humiliate, or injure Ms. Loggins. Now, we all saw the video. What's a reasonable explanation for what Mr. Cobb was doing, or what his intent was? He laughed at her. He waved it around, referred to her by name, and called her a dumb bitch. We talked a little bit in voir dire about how we can use facts in front of us to infer what someone's intent was. Based on what you saw in that video, what was his intent? What was he trying to do? He was trying to humiliate her. The last two elements that the state has to prove. Loggins humiliated. When a reasonable person has been humiliated or harassed. Loggins testified that she was. Embarrassed. She said she was humiliated. A reasonable person would be humiliated and harassed by what happened. I told you that image was not meant for anyone else. That it was supposed to be private. She never sent it to the defendant. She certainly didn't give him permission to show everybody who was watching his YouTube channel that photo. I would ask that you find the defendant guilty of unlawful dissemination of intimate image.
Defense.
Thank you, Your Honor. Good afternoon. Thank you all again for being here. I'm going to make a few points for you today before I sit down. First, did the state prove beyond reasonable doubt today that the photo and evidence is an intimate image? In order to prove that the image is an intimate image, the state must prove that intimate parts are visible in the photo. There are no uncovered human genitals or pubic areas shown in this photo.
So, per the definition that you will receive in your jury instructions, the state must prove beyond a reasonable doubt that female nipples are visible in the image. The state has not met its burden because it is not possible to tell from this image whether Ms. Loggins' nipples are exposed or covered. Now I'm going to repeat that. You do not believe beyond a reasonable doubt that the photo contains a visible female nipple. The state has not met its burden of proof in this case today. Okay. Second, the state must prove beyond a reasonable doubt that the image is an identifiable image of Ms. Loggins. Ms. Loggins testified that it was. The statute demands that a reasonable person would be able to identify the individual in the image. The state provided an image showing Ms. Loggins has a similar tattoo as the individual in the image. But it's not possible to determine whether the tattoo is identical. It's not possible to determine whether two people could have the same tattoo. It is not established beyond a reasonable doubt that Ms. Loggins is depicted in this image. Third, the state must prove beyond a reasonable doubt that the image was disclosed. Definition of disclosure will be provided in the jury instructions. However, common sense tells us this. If someone has already seen an image, seeing it again is not the disclosure. Mr. Cobb had 23 viewers on his live stream. He displayed the image. You can see that in the video the state provided. The stream is no longer posted. No one else can see it. One viewer is Ms. Loggins. The other viewer was an associate of Ms. Loggins who was already aware of the photos. Loggins testified she and Mr. Cobb have the same community on YouTube. Testified that they post somewhat similar content, discuss the same people, talk about the same things. It is likely that some portion of her viewers are also viewers of Mr. Cobb's content. It is not proven beyond a reasonable doubt that 21 members of a small online community did not already have access to an image that was everywhere. Remember, Ms. Loggins testified today, as early as August 28, 2022. She told a friend that her images were everywhere already. She was surprised her friend hadn't seen them. She sent her friend the images. That means by the time the incident in this case allegedly occurred, she'd been aware for over 2 months these images were already everywhere. It's her word. To the extent that she was surprised that another member of her community hadn't already seen them. Wouldn't that mean she was surprised that every member of her community hadn't seen them? Now, fourth, the state must prove beyond a reasonable doubt that Ms. Loggins was harassed, humiliated, or injured. Loggins testified that she was. However, she also testified she'd been talking about these photos on numerous live streams and occasions. It was possible she was discussing these photos on live streams prior to November 19, 2022. And she personally sent the images to a community member in a direct message. Testified she discussed this case on at least one live stream on her own channel. You know her channel is monetized, which means she is drawing money using this incident. Ms. Loggins must be well aware that in drawing further attention to these photos, expanding their profile, she ensures more people will seek them out and view them. They're everywhere. This is not the actions of a humiliated person, it's the action of an opportunistic person. Fifth, the state must prove beyond a reasonable doubt that Mr. Cobb knew or reasonably should have known that Ms. Loggins did not consent to this particular disclosure. How could Mr. Cobb possibly have known that a photo that's being passed around freely within his community was not released by Ms. Loggins on purpose? Finally, a few words on something called chain of custody. Plain to see that the video clip the state provided as evidence in this case is modified. You'll get an instruction on what that means for you as jurors. But I can tell you, the video was cut in a way that, as you saw, it repeats over and over. It gives a false impression of the event. The images provided, or
The video clip was provided by a third party, Ms. Loggins, who then provided it to the state. No way of knowing whether or not it's been tampered with, altered, modified in some more subtle way. No way of knowing that. Mr. Amundsen will get another chance to come up here and talk to you again. Here's what he can't do. He cannot change the evidence that's been presented in this case. He cannot change what's been said, shown to you. He cannot prove essential elements of the charge of unlawful dissemination of image. Therefore, I will ask you to return a break not guilty.
Rebuttal, Mr. Amundsen.
Yes, Your Honor. I'd first like to address one of the points discussed by Mr. Holman. The term disclosed. Today you're going to be instructed that to disclose includes, but it's not limited to, transfer, publish, distribute, exhibit, advertise, or offer. Mr. Cobb showed everybody on his live stream that image. He disclosed it. Now, regarding intimate image, you have the photo. You can look at the photo and you can clearly see what's in it. I won't belabor that point because you can all see it for yourselves. Identifiable. In the video, he said her name. Referred directly to her. And in the photograph, you can clearly see an identifiable tattoo, a unique tattoo. You can also see on Ms. Loggins. Got pictures of both. You can look at those two pictures and reasonably think that it's the same person, then it's identifiable. Mr. Holman also pointed out that Ms. Loggins has discussed this case and this incident on some of her live streams. I want to kind of address specifically what she actually did say. What she said was that people were asking her questions about it. That doesn't mean that she was trying to draw attention to it. That means that she couldn't continue to be online and do what she wanted to do without being asked about it. If anything, that demonstrates that she has experienced harassment due to the incident and due to the image being disclosed. It has also been argued that the defendant did not know that she did not consent to him showing everybody the picture online on his YouTube. She did tell you that she never consented to that. She told you that she never gave that impression. She told you that she never even sent him the picture in the first place. By that, with the way that he was acting and the things he was saying on the video, pretty much tell you that he knew he wasn't supposed to be doing it. He said several times, I'm going to do it, I'm going to do it, I'm going to do it. That's not somebody who had consent to share that. Whether or not that image had been sent to other people, whether or not she had sent it directly to someone who she wanted to send it to, that does not mean that the defendant has the ability to, once he gets his hands on it, to share it with whoever he wants to and to publish it online. Regardless of what you may or may not think about whether or not it was wise for Mrs. Loggins to send that picture or that video to someone else, it doesn't give the defendant a right to share it with the world, to humiliate her. Ladies and gentlemen, you've seen all the evidence, you've seen the picture, you've seen the video. It's all right there. I would ask that you find the defendant guilty. Thank you.
The functions of the court and jury. It is your sole responsibility to make all the decisions about the facts in this case. You must evaluate the evidence to determine how reliable or how believable that evidence is. When you make your decision about the facts, you must then apply the legal rules to those facts and reach your verdict. Remember, however, that your power to reach a verdict is not arbitrary. When I tell you what the law is on a particular subject or tell you how to evaluate certain evidence, you must follow these instructions. Do not allow anything I have said or done during the course of this trial to suggest that I have formed any opinion about this case. Keep in mind that a judge is required by law to give certain instructions in every criminal case. And you'll note there's a typo on that line. There's a hyphen in the middle of the sentence, instructions. That's my typo. When I have sustained objections to evidence or ordered that evidence be stricken or excluded from your consideration, you must follow these rulings. Do not consider such matters during your deliberations. Base your verdict on the evidence and on these instructions. The lawyer's statements and arguments are not evidence. If your recollection of the evidence is different from the lawyer's recollection, you must rely on your own memory. In deciding this case, you are to consider all of the evidence you find worthy of belief. It is your duty to weigh the evidence calmly and dispassionately and to decide this case on its merits. Do not decide this case on guesswork, conjecture, or speculation. You should make every effort to be aware of your biases, including unconscious biases, and what effect those may have on your decision-making. In your deliberations, you must not be biased in favor of or against any party, witness, or lawyer because of the person's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we are not fully aware of. These hidden thoughts can affect what we see and hear, how we remember what we see and hear, and how we interact with others. They also may affect how we make important decisions. Do not allow any personal feelings, sympathy, prejudice, or bias, whether conscious or unconscious, to influence your decision-making. Do not consider what sentence the court might impose if you find the defendant guilty. Generally, the testimony of any witness whom you believe is sufficient to prove any fact in dispute. You are not simply to count the witnesses, but you are to weigh the evidence. Keep in mind that each party is entitled to the considered decision of each juror. Therefore, you should not give undue weight to another juror's notes or memory if they conflict with your recollection of the evidence. The court has provided written instructions for your use, and they're the instructions that I'm reading. When you use these instructions, do not place undue emphasis on any particular instruction, but rather view the instructions as a whole. Evaluating witness testimony. The term witness includes every person who has testified under oath in this case. Every witness has taken an oath to tell the truth. In evaluating each witness's testimony, however, you may consider such things as 1. The manner in which the witness testifies. 2. The nature or quality of the witness's testimony. 3. Evidence that contradicts the testimony of the witness. 4. Evidence concerning the bias, motives, or interests of the witness. Modified evidence. During the trial, the court may have received evidence in a modified form. The evidence may have been edited because it contained irrelevant or otherwise inadmissible material. If you notice or suspect that evidence has been modified, you are not to speculate about the substance of what may have been removed or modified or why it was modified. You should not consider evidence to be of greater or lesser evidentiary value based solely on the fact that it has been modified. Inferences. In deciding this case, you may draw inferences and reach conclusions from the evidence if your inferences and conclusions are reasonable and are based on your common sense and experience. Innocence of the defendant, proof beyond a reasonable doubt. The defendant is innocent unless and until the defendant is proven guilty beyond a reasonable doubt. The burden is on the state and the state alone to prove the guilt of the defendant beyond a reasonable doubt. Reasonable doubt is doubt based on common sense and reason. Reasonable doubt is not an imaginary doubt. Reasonable doubt means an honest uncertainty as to the guilt of the defendant. You must return a verdict of not guilty if, after careful and impartial consideration of all of the evidence in the case, you are not convinced beyond a reasonable doubt that the defendant is guilty. Defendant's statements. When a witness testifies about statements made by the defendant, you should consider such testimony with caution. In reviewing such testimony, you should consider, among other things, the following. 1. Did the defendant make the statement, and if so, did he clearly express what he intended to say? 2. Did the witness clearly hear and understand what the defendant said? 3. Did the witness correctly remember and relate what the defendant said? 4. Did the witness intentionally or mistakenly alter some of the defendant's words, thereby changing the meaning of what was actually said? If, after weighing such factors, you conclude that the defendant said what he intended to say, and that the witness to the statement correctly understood, remembered, and related to you what the defendant said, then you are authorized to consider such statements for what you deem them to be worth. Direct or circumstantial evidence. There are two types of evidence. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, the proof of a chain of circumstances pointing to the existence or non-existence of a certain fact. You may base your verdict on direct evidence, or on circumstantial evidence, or on both. Non-expert opinion evidence. Although a witness may be allowed to state his or her opinion, you are not required to accept that opinion. To determine what value, if any, you will give to a witness's opinion, you should consider such things as the witness's opportunity and ability to form the opinion, the witness's believability, and how the witness reached the opinion. Evaluating witness testimony, witness false in part. Sometimes a witness may give incorrect or even inconsistent testimony. This does not necessarily constitute lying on the part of the witness. The witness's testimony may be an honest mistake or confusion. The witness may simply forget matters, or his or her memory of an event may contain honest inconsistencies or contradictions. Also, different witnesses may observe or recount the same event differently. However, if you find that a witness has intentionally lied in part of his or her testimony, you may, but are not required to, distrust other portions of the witness's testimony. As jurors, you have the sole responsibility to determine which testimony or portions of testimony you will or will not rely on in reaching your verdict. Intentionally and with intent. A person acts intentionally or with intent when that person acts with a conscious objective to engage in particular conduct. When used in the phrase, intent to harass, humiliate, or injure SL, intentionally or with intent means that a person acts with a conscious objective to harass, humiliate, or injure SL. Knowingly and with knowledge. A person acts knowingly or with knowledge if that person acts with an awareness that his or her conduct is of a particular nature. When used in the phrase, knowingly caused to be disclosed an identifiable image of SL whose intimate parts were visible, knowingly or with knowledge means that the person acts with an awareness that he caused to be disclosed an identifiable image of SL whose intimate parts were visible. Knowledge is also established if a person acts intentionally. Definitions. Disclosed. Includes but is not limited to transfer, publish, distribute, exhibit, advertise, and offer. Identifiable means that a reasonable person would be able to recognize the individual depicted in the image as the other person. Image. Includes but is not limited to a photograph, film, videotape, recording, digital picture, and other visual reproduction regardless of manner in which the image is stored. Intimate parts. Means uncovered human genitals, pubic areas, or female nipples. Unlawful dissemination of an intimate image. Oregon law provides that a person commits the crime of unlawful dissemination of an intimate image when the person, with the intent to harass, humiliate, or injure another person, knowingly causes to be disclosed an identifiable image of the other person whose intimate parts are visible or who is engaged in sexual conduct. The person knows or reasonably should have known that the other person does not consent to the disclosure. The other person is harassed, humiliated, or injured by the disclosure, and a reasonable person would be harassed, humiliated, or injured by the disclosure. In this case, to establish the crime of unlawful dissemination of an intimate image, the state must prove beyond a reasonable doubt the following elements. 1. The act occurred on or about November 19, 2022. 2. Douglas Cobb, with the intent to harass, humiliate, or injure SL, knowingly caused to be disclosed an identifiable image of SL whose intimate parts were visible or who was engaged in sexual conduct. 3. Douglas Cobb knows or reasonably should have known that SL did not consent to the disclosure. 4. SL was harassed, humiliated, or injured by the disclosure. And 5. A reasonable person would be harassed, humiliated, or injured by the disclosure. The verdict. When you return to the jury room, select one of your members to act as the presiding juror. The presiding juror has no greater voting weight, but is to preside over your deliberations, be the spokesperson for the jury. You should then deliberate and find your verdict. If it becomes necessary during your deliberations to communicate with me, do so in writing. I will consult with the parties before responding. No one, except for you, the jurors, is to be involved in your deliberations. Therefore, do not tell anyone, including me, how many of you are voting not guilty or guilty until you have reached a lawful verdict or have been discharged. Each and every juror must agree on your verdict. So whether your verdict is not guilty or guilty, all of you must agree on the verdict. If you are divided 5-1, for example, you do not have a verdict. When you have arrived at a verdict, the presiding juror will sign the appropriate verdict form. After you have reached your verdict, you'll signal the bailiff, and that's my assistant, and the court will then receive your verdict. The way you will signal my assistant is if you have noticed just to the left side of the door, there's a white button on the inside of the door. It looks like a doorbell. It is a doorbell. It rings a doorbell just outside my assistant's office, and she can watch the courtroom through the video system. She will then come in to see if you have a question or a verdict. The verdict form that will go back with the jurors is this verdict form here. It says, we, the jury, being duly impaneled and sworn in the above entitled court and cause, do find the defendant, as do count 1, unlawful dissemination of an intimate image. There is a line that says not guilty. Below that, there is a line that says guilty. The presiding juror will mark the appropriate line based on the jury's unanimous verdict. Then there is a line for the date. Today is the 8th day of September 2023. There is a line for the presiding juror's juror number, and then below that a signature line for the presiding juror. Do you solemnly swear that you will take charge of this jury and keep them together until they have reached their verdict? That you will not, unless by order of the court, allow any communication to be made to the jury except to ask them if they have agreed on a verdict? That you will not communicate to anyone the state of their deliberations or the verdict agreed on. That you will perform these duties in accordance with all applicable ORCPs to the utmost of your ability, so help you God. Right, the jury is yours. So members of the jury, if you'll head back into the jury room now, and after my assistant leaves, you may start deliberating. Any exceptions to the jury instructions from the state?
No, Your Honor.
Any exceptions from the defense?
No objection.
What was that?
No objection. Yeah.
All right. And we'll be in recess until the jury reaches a verdict. If you'll make sure my assistant has your contact information, and then Mr. Cobb, just make sure you stay within 5 minutes of the courthouse so that we can reconvene when the jury comes back. We'll be in recess. All right, we are back on the record. My assistant let me know that we have a verdict. Are the jurors or the parties ready for the jury to be brought in?
Yes, Your Honor.
Yes, sir.
All right, we'll bring in the jurors. Juror number 75, I saw you had a single white sheet of paper. Are you the presiding juror?
Yes.
And has the jury reached a verdict that all 6 jurors agree on?
Yes.
Is that shown on that document?
Yes.
Will you hand it to my assistant, please? Mr. Cobb, if you'll please stand. The verdict reads as follows. We, the jury, being duly impaneled and sworn in the above entitled court and cause, do find the defendant as to unlawful dissemination of an intimate image. It is marked 6 on the line guilty. It is dated this date, signed by the presiding juror. Would either side like the jury polled?
No, Your Honor.
No, Your Honor.
Mr. Holman, would Mr. Cobb like to go to sentencing today or have a time set certain next week?
I have a brief moment, Your Honor.
You may.
Sentencing today, Your Honor.
Is the state prepared for sentencing today?
Yes, Your Honor.
All right, I'll hear from you first.
Your Honor, Ms. Loggins would like to make a statement today.
Is she here?
Oh, never mind, Your Honor, no statement.
Okay.
So, Your Honor, in this case, state recommends suspending a position of sentence, 18 months formal probation, standard conditions, or all general conditions, and special conditions to include sex offender evaluation and treatment if recommended, 7 days Polk County Jail, 120 hours of community service, no electronics or social media without PO permission.
Go back for a second. You said sex offender evaluation if recommended?
And treatment if recommended.
Okay. And then continue from there.
Yes, Your Honor. 7 days Polk County Jail, 120 hours community service, no electronics or social media without PO permission, no sexually explicit material, and submit to search and no contact with the victim.
Mr. Holman? Well, let me back up before I go to you, Mr. Holman. Mr. Amundsen, does Mr. Cobb have any criminal history?
My apologies, Your Honor. 2011 possession of a controlled substance, 1 out of Clatsop County.
Is that a felony?
Yes, Your Honor.
Okay. Mr. Holman?
Thank you, Your Honor. And we would simply ask, given the lengthy pendency of this matter, Mr. Cobb has been having struggles with securing a job. Truly, I think that this is already a full-time job. I apologize. This has already been a substantial hardship for him. I think that the imposition of probation and evaluation treatment is appropriate. Community service hours are appropriate. We would ask that the court consider not imposing jail time in this case.
Mr. Cobb, now is your opportunity to make a statement before I impose a sentence. If you don't want to say anything, sir, you don't have to. But if you would like to, I'll hear from you now.
I just wish the jury got to see everything that I had presented to my lawyers.
Anything else you want to tell me, sir?
Not off the top of my head, Your Honor. Otherwise, I help my mom. My mom's elderly, so like me going to jail would be a burden on her. So.
So, sir, I am going to suspend the imposition of sentence and place you on 18 months of supervised probation. Conditions of your probation will be all general conditions plus the following special conditions. There will be a sex offender evaluation and recommended treatment if appropriate. 120 hours of community service. I'm going to order no contact with the named victim in this case. So Ms. Loggins, Loggins. I am not going to order no electronics. You will need to submit to searches by the PO if they have appropriate cause. And no sexually explicit media or things of that nature you will be allowed to have while on probation. I am not going to order 7 days in the Polk County Jail at this time. I will order that you appear to, it's 2:43, that you appear to probation today. Their office is 1.5 blocks to the west of us. They are right across the street from the Dallas post office. You'll need to go there today before 5 o'clock. My assistant will give you an information to get there. If you do not go there today, that will be a violation of the terms and conditions of your probation.
Understood.
And Mr. Holman, do you have a notice of advice of rights to appeal?
I was just handed one, Your Honor.
Okay. If you'll fill that out, please. And members of the jury, I'm going to send you back to the jury room one more time. And you are complete for today.